number 6, Greene versus Esplanade Venture Partnership.
Good afternoon, Your Honor.
Good afternoon. Let's wait a moment until your colleague appears on the screen and we get Judge Feinman back.
I'm back.
Okay, great. Thank you. Good afternoon. This is appeal number 6, Greene versus Esplanade. Counsel?
Good afternoon, Your Honor. Ben Rabinowitz from Gagar Conason for the plaintiff appellant. Your Honor, I respectfully request 2 additional minutes for rebuttal.
You'll get 2 minutes for rebuttal, sir.
Thank you. Your Honor, in this case, the unthinkable happened back in May of 2015. And the question is whether a grandmother who was only 60 years old at the time, who witnessed her granddaughter crushed in front of her eyes, should be able to recover for the emotional damages, for the zone of danger damages.
Counsel, why is the bystander claim necessary here where the grandmother sustained her own injuries?
Because it's not just her own injuries that matter. In witnessing the death of her grandchild, as has been stated by Judge Miller below, you would go through metaphysical gymnastics trying to separate what she is feeling, the emotional trauma in witnessing that granddaughter's death, and separating that from her own emotional damages. They're all part of the same thing. And that's what the court actually spoke about in the Bovson case some 38 years ago. So when they said that you're entitled to recover for these emotional damages, for the negligent infliction of emotional distress, and they defined this by saying if you're within the immediate family, you can recover for zone of danger damages. Certainly a grandmother should be one who is in the immediate family. And the Court of Appeals has never before answered the question as to whether or not a grandmother is. But if we take a look at what has happened in the 38 years from the time that the Bovson court decided this, certainly the family structure has
changed. If I may ask a question?
Yes.
Judge Rivera.
Thank you. So you said the court has never decided that grandparents don't fall within that immediate family, but doesn't Trombetta go against that position? Don't we have to overrule that part of Trombetta that said immediate family is limited to basically parents, siblings, and children? Don't we have to overrule that, or is there a way to avoid that?
I think you actually should be overruling the Trombetta case because it is not in keeping with the restatement of torts, which was something that was relied on when we take a look at the Bovson court, and we take a look at what really did happen. In Trombetta, you did have an aunt who raised the child, and what I'm saying is, here, if we take a look at what the restatement of torts third is saying, they're saying close family member. Every other state that has allowed...
May I inquire?
Please.
I'm confused. Why do we need to adopt the restatement? Now, I understand there's policy arguments about different kinds of families and all of that, but that's not what we have here. Couldn't we just fit the grandparents into our current framework, which is immediate family member within the zone of danger? And because of changes in our law, even assuming Trombetta says what you say it says, which I don't necessarily think is true, but why can't we say because of changes in our law, recognizing grandparents as a special class, why can't we do that without throwing out years and years and years of very careful, deliberate expansion of this area of law and wait for the next case to come before us in which maybe it's not a grandparent, maybe it's something else. I don't understand why we have to take a giant step in this case when there's another way to grant relief if that's what we think is appropriate.
So, Judge Stein, you ask a very good question. I happen to agree completely with you. If we take a look at the standards set forth in Bovson, which is immediate family member, a grandmother certainly falls within immediate family member. And the reason I say that is because of the reality of today. We don't have a stay-at-home mom anymore. We have non-traditional families where the grandmothers take care of the grandchildren while the mothers work. And in fact, they're part of the immediate family. So I happen to agree completely with you. We don't have to undo that at all if we follow the immediate family member as laid out in the Bovson case itself. All I was saying with respect to the American Law Institute was when they take a look at the restatement of torts, they now have gone away from immediate family member and they say close family member.
But don't
But I
they
happen to
also
agree
get
with you.
away? Don't they also get away from the zone of danger rule when they talk about perceiving an event? And I mean, to me, that's a pretty big jump.
Well, what they're also saying is that the zone of danger for those individuals who are within the zone of danger, they certainly say that a grandparent is part of that. And they've made it very clear, just as we're saying, when you take a look at the law in New York, if you take a look at the domestic relations law, you can see immediate family member.
Chief, if I may.
Yes, Judge Feiman.
Mr. Rabinowitz, I think what Judge Stein is getting at is there a way to give you the relief that you want that is incremental without eliminating the zone of danger requirement, which I think everybody concedes is satisfied here, and then leave some of these other issues to the next case? And how would you do that?
So, Judge Feiman, what I would say is this. The immediate family member, if I understand your question correctly, what you're saying is, yes, a grandparent is an immediate family member, and that would leave the law intact. And certainly what I'm saying and what Judge Stein asked, and I happen to agree completely with what Judge Stein said, yes, a grandmother is within the immediate family members, and that would certainly leave the law intact. But what we're saying is, you can't say that a title alone, grandparent, therefore we're going to say, if it was a mother, it's okay, but if it's a grandparent, no, it ignores the reality of what's going on. If, for example, a mother died during childbirth and raised by the grandparent, the grandmother, certainly that grandparent is part of the immediate family member and has to be. And that's why I happen to agree with what Judge Stein said. And
Judge, if
Your
I
Honor,
may ask, counsel, that sounds a lot like close family member. That sounds a lot like what the restatement third is trying to do, which is expand the understanding of nuclear family, the family that would, a family member who would most react to, as you're saying, a horrible witnessing of harm to another family member. It sounds a lot like the same thing.
I understand your question, Your Honor. And what I'm saying, Judge Rivera, is this. Yes, if you take a look at it, certainly within the standards set forth in Bobson, Susan Frierson, as a grandmother, should be able to recover for zone of danger damages. I happen to agree with you that, yes, the restatement third does expand it when they say, for example, close family member as opposed to immediate family member. I'm saying either way, in this case, this grandmother should be able to recover.
That's fair. Let me ask you this. I just want to clarify. With respect to your understanding of our zone of danger test and jurisprudence, does the zone of danger require that the...
I lost.
Judge Rivera? Can't hear you.
I'm sorry, my apologies. Does the zone of danger test, as New York has adopted it, require, let's just take a parent to make it easy, that the parent themselves suffer an injury, or they just have to be within the zone of danger, regardless of whether or not they suffer their own injury? I just want to know your position on that.
Okay. First, I will point out that Susan Frierson, the grandmother here, did suffer an injury. But our position is it is not necessary, and I refer the court to Battaglia, for example, Battaglia versus State, where in fact emotional damages have been allowed without a physical injury, and they've updated that since the doctrine many, many years ago, 40 or 50.
Say no injury at all to the individual. If the only, let me put it this way, if the only damages that the individual is, the parent in my hypothetical, is seeking is for the emotional disturbance they suffer as a consequence of witnessing the horrendous injury or fatality to the other family member.
Yes.
Your understanding is under our zone of danger standard and jurisprudence, they can collect. They need not have any physical or emotional injury unique to themselves, correct?
That is correct. And in this case, what I'm saying is, although I say that's correct, Susan Frierson did suffer injuries to both her knee and to her ankle when that debris fell 8 stories from the negligently maintained facade on that building.
Thank you, counsel. Counsel?
Judge,
I'm sorry.
Can
Judge
I
Stein-
ask Mr. Rabinowitz, because I want to get this from
Yes.
both counsel.
Yes, of course.
Uh, what we're struggling here with is the nature of the barriers that we're trying to erect within the zone of danger and who it applies to. And is there a definition that you would point us to outside of the third restatement for immediate family that you'd want us to look at?
Yes, Your Honor. I would ask you to take a look at, for example, knowing that many of you were, for example, district attorneys or assistant DAs, or you had worked in the criminal field. If you take a look at, for example, the penal law defining murder in the first degree, an immediate family member of a witness to a crime includes a husband, a wife, a father, a mother, a daughter, son, brother, sister, grandparent, and grandchild. It says it specifically. So what I'm saying is, if we take a look, but there's more than that. If you take a look at the election law, it says the same. Grandparent is included. The public health law, it says the same. Grandparents are included. The domestic relations law recognizes the special relationship between a grandparent and the grandchild. The rent stabilization code refers to grandparent and grandchild.
So let me ask you the next question. I get your point, but so let's say we can reach the grandparent. Actually, I find to be relatively easy. You have both a familiar, or if you wish, a genetic bond, and also a social bond that's usually pretty strong. And it's easy to include that person within the immediate family penumbra. But what about, does this mean that we would go through the process with each type of relation that maybe suffered a negligent infliction of emotional distress within the zone of danger? Let's say you come up with someone's a cousin, you come up with someone's stepsister. Do we have to go? Would we go through that analysis each time, or is there a rule we can point to that would include those kind of people, or factors that we should look at that would include those kind of people if it will be appropriate to include them within immediate family? You know, my experience with family in my lifetime is that it's changed a great deal. And when I was a young man, it was June Cleaver. Now it's Modern Family. And I think that paradigm has been reflected in all of our lives. And so I'd like us to not deal with each relative one at a time in the Court of Appeals, that we'd have some rule and some guidance for the trial court that we can offer them. I'm wondering if you have one for us.
Yes, Your Honor, I actually grew up about the same time that you did, so I understand those two analogies.
Another old man, huh?
I guess so. But my point is this. I see what you're saying, and you'd be struggling with a qualitative analysis where we try and evaluate the quality of the relationship for each specific case. In other words, let's look at the quality, let's look at the integrity of that relationship. I'm saying we don't even have to do that here, because here we do have a grandmother who is within the immediate family, which is what Bobson said originally. And I'm saying if we take a look at that, certainly this grandmother falls within the immediate family. We don't even have to go to the third restatement of torts. We don't have to go to a qualitative analysis to determine whether or not the quality of that relationship.
And how do we as a court deal with that problem of each individual family relationship that over time may fall within negligent infliction of emotional distress claim? They have damages, they're within the zone of danger. How is there a way to do that so that we don't have to relitigate this every single time there's a different familiar relationship that we're confronted with?
I think the way to do it is to get away from the title if you really wanted to. And instead of saying the title, let's take a look at the nature and the extent of the relationship. Let's take a look at the quality of that relationship, and let's take a look at the integrity of that relationship. Because whether you choose to call it a grandmother, a grand person, or you choose to call it, for example, somebody who is actually there as a part of that nuclear family, are they really there? Are they really offering the quality, that integrity? Is it part of that relationship? And I think,
Chief, if I may follow up, if that becomes the rule, then you basically could never grant summary judgment on the relationship, because by definition, those are all going to be fact-intensive inquiries, correct?
I understand your question, Judge Feynman, and the answer to your question is yes. I'm saying here we don't even have to do that because Susan Frierson.
I understand this case, but Judge Fahey is
yes.
getting to trying to create a more general rule of general applicability. And so what I'm trying to figure out if there's some sort of rule that provides guidance, but allows courts to weed out either at the motion to dismiss or the summary judgment stage, those claims that maybe shouldn't go to a jury. The way I understand your articulation of the rule, summary judgment would have to be denied in every single case, or the motion to dismiss would have to be denied in every case.
That I believe is why the restatement actually went to close family member to answer the exact question that you're asking right now. Because what they're saying is here, take a look at that relationship. Are they close? What I'm saying is here in our case, with Susan Frierson witnessing the death of Greta, who was 2 years old when she was 60, I'm saying you don't even have to go that far. But certainly, if you follow the restatement, which is what the Bobson Court did some 38 years ago, the restatement now says close family member, and every other state that follows it
Chief, may I
allows grandmothers.
I know we're over time. Chief, may I ask a question? I know we're over.
Yes, Judge Garcia, please.
Counsel, I think with that kind of summing up here, it goes back to what Judge Rivera, I think, was getting at in very early stage of this argument, which is you keep talking about Bofson, but the only marker this court has laid down since Bofson was really a case that pulled that back in a way and reemphasized the need to Trombetta to limit that type of liability. So what you're asking us to do, I think, as Judge Rivera was saying, is really overrule the one marker that came out 10 years after Bofson, which unanimously, and Bofson, as Trombetta says, was a very closely divided court, but Trombetta 7-0 said, you know, we have to really be circumspect in expanding this type of liability. And I think if it didn't do anything else, really closed off that kind of functional look at what role do you play in a family structure and went with categories. Now, you know, I take Judge Fahey's point in your answer that may have changed over time, but the only case it seems to me this court has decided since Bofson put an end to that type of analysis.
So Judge Garcia, I'll answer it this way. Yes, Trombetta was 28 years ago, and you did anticipate this in your question to me, and I respect that, where you said the family has changed, and it has. And that's why the restatement has actually said we have to look at the close family relationship.
Pretty much that argument in Trombetta, because the argument was made there that I think it was a niece and an aunt, that was in essence a mother-daughter or a type of close family relationship that was similar to what we had said was okay in Bofson. And I think we rejected that. So I think your argument though now is we shouldn't reject that type of functional test, but it seems for policy reasons, that's exactly what we rejected. It wasn't that we said that doesn't happen. It was we said we were not going to consider that for liability here.
So once again, I go back to the point that this is a grandmother, that was an aunt. But even with the aunt, I am saying with the things that have changed in the last 28 years since Trombetta was decided, yes, we now have very different family structures. And because of that, what I am saying is that the law has to change and it has to keep up.
Wouldn't that argue for even more of an adherence to Trombetta? Because now you have an expanded pool who under a functional test, you know, what role do you play with respect to this person? And does it emulate a father, son, mother, son? You know, now we have a larger pool of potential candidates. And if you go to Trombetta saying, you know, there are very strong policy reasons to limit this liability, then your argument to me makes the Trombetta court's point stronger. Yes, there's even more people that could potentially qualify now.
I'm saying here specifically, this grandmother does qualify under Bobson as it was written. But I am also saying that certainly what happened in Trombetta with an aunt who was a de facto mother, we shouldn't just look at the title of somebody being an aunt or an uncle or a stepmother. What I am saying is let's take a look at the relationship and let's take a look at the integrity of that relationship, because that's terribly important. And when something happens like this, there has to be a remedy under the law because otherwise it would result in such injustice not to be able to do this. This is something that is terribly, terribly important, where, for example, this grandmother witnesses her grandchild crushed in front of her. They did nothing wrong, nothing to cause this, but the defendants submit a false inspection report.
Counsel, we understand, and the facts in this case are compelling, but as I think Judge Fahey has been pointing out, we're looking to make a rule here. So, we have to consider, the landscape well beyond the compelling facts that you're arguing to us now.
So I
Thank you,
would suggest.
counsel. Thank you, counsel. Counsel?
Good afternoon. May it please the court, Jonathan Schaub for the respondent Esplanade Venture Partnership. I'd like to begin where Mr. Rabinowitz left off with the idea that this is an open question that grandparents are included in the immediate family test. It's not. Trombetta, as Judge Rivera noted, limited immediate family to parents, spouses, and children. So proceeding from that point, what Mr. Rabinowitz is asking us to do is expand the orbit of duty in a carefully and narrowly recognized area of the law that this court has taken great pains to circumscribe liability.
Well, let me ask you, can I ask something, Judge?
Yes, please.
Mr. Schaub, what would the public policy reason be to not include a grandmother as part of an immediate family?
So the issue here becomes this court drew a boundary at a very logical.
No, I understand that, but let's address this case. Let's just say that we don't adopt the third restatement, but we do consider whether or not the grandmother is included within the immediate family jurisprudence of this court. What public policy reason would there be for us not to include a grandparent, forgetting the individual?
So what we're doing here now is expanding the class of plaintiffs who can recover from, right now you have one spouse, two parents. And what that is now doing is doubling the number of people who can recover.
I get that. I get the numbers, but the normal public policy reasons that oppose this kind of action are flood of litigation is claimed, emotional damages that can be faked. The damages are speculative. I find no evidence of that. I don't think there's a state you can point to or empirical proof for any flood of litigation that takes place by an expansion of this particular right to recover. And there was none that anyone's offered as an argument in this case. Emotional damages can be faked. That's a 19th century notion that is really outside of our jurisprudence. And things like PTSD should have really cured any court of ever thinking that emotional damages can be faked and they don't really exist. So I guess what I'm saying is just limited to the grandmother or the grandparents. How would this affect any of those normal public policy arguments against this?
So I think the problem becomes if you start at grandparents and you've moved the field of those core relationships, there's no limiting principle.
So it's the thin edge of the wedge kind of argument. Is that,
right.
Is that what you're saying?
It's a slippery slope. And I would add in the other jurisdiction.
Can I question on that? Counselor, would you agree that at least insofar as our fairly recent decision in Suarez is concerned, that we have given grandparents a special status in relation to children, to grandchildren? So wouldn't that possibly be a limiting factor?
So the status that the grandparents have been afforded as it relates to grandchildren is as it relates to the best welfare of the child. We're talking about tort duties here, and in defining tort duties.
I understand, but in talking about what one has to do to get custody, as opposed to a parent. We specifically recognize the special relationship that grandparents have in our society today, and so on and so forth. So, I don't think it's just limited to the best interest of the child. We made a statement about the role that grandparents play, and it's really not, it's not a huge step.
I do not disagree that grandparents play an important role in the modern society. In fact, my parents are watching my children right now. I completely agree with that and understand that. But the point is that relationship and that special relationship is still not akin to the relationship between a spouse, a parent, and a child. And those are recognized and afforded constitutional protections. And if we start going down the road of looking at what statutes and cases have said, it will not be very long until the next plaintiff comes in, pointing to some piece of legislation or some language in the decision saying there's a special relationship. And this builds on another point. The legislature has considered this exact issue on 3 separate occasions and considered bills to modify the general obligations law and the CPLR to include grandparents as immediate family members. And on each and every one of those occasions, the bill is not passed, which demonstrates that they're not immediate family members for purposes of.
Well, it may demonstrate a lot of different things, but the definition and even the category of immediate family member in this context has always come from the court. So, I don't know that I agree with you that this is a matter that the legislature has to address.
Respectfully, Your Honor, this court has recognized, though, in areas of public policy with expansive potential for liability, that it is oftentimes with economic ramifications, it is best left to the legislature to decide this. And I think this court, with all.
Well, but you could also say conversely that if the legislature didn't want this to be, the legislature could limit it.
Correct, but as it exists now, there was the Guan case, which shows that grandparents were not recognized as grandparents. And in the face of that decision, the legislature has failed to pass this legislation. So legislative inactivity is evidence that it is, or in this case, it is activity, it's the failure to pass it. It is evidence of the fact that the legislature is happy with where, I'm sorry, it's happy with where, I'm sorry, it's happy with where the line's been drawn.
Yeah, I want to turn to a different issue, which is if you can comment on something that came up in the discussion with Mr. Rabinowitz about in a situation like this where there actually has been injury to the grandmother, how does a court go about talking to a jury about, and this goes back, I think, also to the Chief's very original question in this argument, the emotional damages that she may have suffered for her own injury versus the emotional damages that she suffered because of what she witnessed the grandchild go through. I mean, she gets up on the stand and she testifies, I'm depressed, I have insomnia, I can't sleep. Sometimes I dream about my granddaughter and then relive the accident. Oh no, you can't consider that. But practically, how does that work?
So I think as a practical matter, this goes to the issue of the trial judge's gatekeeper function, and the evidence relating to that would not be admissible. It would, the testimony relating to this would be limited to her specific damages, unrelated to those involving the death of.
So what if she says, I'm insomniac now and I'm depressed, and doesn't talk about, I'm dreaming about the granddaughter? Does the judge have to give an instruction? You can only consider that as a relation to her own self, but don't think about the granddaughter. I mean,
but I mean, there would be arguments.
The parsing is that I'm having.
So, but in that circumstance, there are always situations where the court limits the testimony, and our system is built on the notion that the jury can follow instructions. If we abandon that idea and that principle, there's far-reaching implications, and that is not to say that we don't consider the jury's ability to follow jury instructions. I don't think that would be a problem, and I think this idea that they may be led down the path is avoidable if the evidence, and the trial judge carefully monitors the evidence and the argument that counsel makes in openings and summations. This really shouldn't be an issue that comes up.
So one last question from me anyway, which is there any data, you're making the floodgates or the wedge argument, but is there any data with all these other states, and I'm sure you've also done the 50-state survey, and obviously the rules are a little different in many different states. But is there any data to really support this notion of we're going to have, you know, an overwhelming tidal wave now of new claims?
So I think the issue is New York State is
assuming, for my question, that we maintain the zone of danger, which you know, obviously is not an issue in this case.
So I think first to answer your last question, Trombetta has said that the immediate family test is the key to avoiding the proliferation of claims, and it is the key to avoid enmeshing this court.
What if they were wrong?
Task.
That's my point. What's the data? What's the data? What's going on in the other states?
Well, I don't think the other states serve as an accurate proxy because New York is different qualitatively and quantitatively than other states in terms of litigation loads and litigiousness overall. But
is there a problem in California?
What?
California is certainly bigger than New York. What's going on there?
But California had this kind of flexible notion of a test, and that was the Dillon case, and it had to abandon the flexible test because in Thing it said it created an unmanageable load of cases where there was no ability for defendants to understand what activity would trigger liability and created unworkable rules for courts. The other problem with trying to draw this type of analogy is, as you've identified, is the disparate nature of this type of claim across many jurisdictions. So there are other jurisdictions that impose more rigorous rules. For example, that you have to have a physical impact or manifestation of a physical injury. Another example is New York says the injury is serious and verifiable, and other states require a far more robust showing to recover for this, being clear and convincing evidence or a severe injury. So it's hard to draw these analogies when we're not comparing tests that states pick different points at which to limit the claim. New York has picked a very rational place at this line.
Judge, if I may ask a question. Judge. So counsel, your arguments are very much in the well-traversed vein of the concerns about liability and torts, right? A robust tort area or something else. So hasn't New York, though, already made a decision through the way we limit this liability to address those concerns? And more importantly, aren't we really talking about a very small class, even if you expanded it, even if you went as far as the third restatement? Bystander liability, by the mere fact that you're going to keep it limited in some way to someone who has a connection to the family. It's not really a pure bystander in the sense of a stranger. We're not talking about strangers being able to collect. Aren't you really already talking about such a small number of cases? This is not really the kind of area that those arguments you're making that are valid arguments in terms of torts writ large really don't make sense here.
So I think that these are the arguments, they do have application here, and Judge Kaye thoughtfully and cogently laid them out in the Bobson dissent in a manner far better than I'll be able to articulate. And it was again articulated in Trombetta that this is a concern with the proliferation of claims here. But separate and apart from that, if we're talking about the relationships here, without an objective standard here, the court will now be in the business of measuring closeness of relationships.
No, but no. But if we're just going to stick with sort of someone who is not a stranger, has some family relationship, the reality is that there is, since 1993, when Trombetta's decided, since 84, when Bobson has decided, we can look to the other states. We can look to what else is going on. And you are not incorrect about California, but California didn't then adopt the kind of test that you're advocating for. I mean, California does have a much broader test than we do. So again, we can look to them, and the sky hasn't fallen.
But again, I think that it was a concern that was articulated earlier, and I think it may have been by Judge Fahey, that there's now no ability to limit these claims in any type of efficient way here, be it on summary judgment, because if we're going to look at the closeness of every single relationship, which is what California does, then that is going to enmesh the court in the business of, and on a case-by-case basis, determining whether someone is close with a particular family member, and that's just not going to be amenable to summary judgment, and it's going to create an unworkable burden on the court.
Yeah, and I'm not sure that I may not share the same concerns about that, given that in the area of torts, so much is not appropriate for a judge to resolve on a motion to dismiss or summary judgment as it stands. It is usually a question of fact that goes to the trier of fact. So I don't know that I share that concern, but I understand your point. Thank you.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. Catherine Herr Solomon of Marl-Lingna Party on behalf of the defendant respondents Blueprints Engineering and Maksud Faruqi. The appellate division's order should be affirmed because there's no compelling reason for this court to stray from its precedent. Trombetta is the deciding case, and it limited the recovery to the immediate the married or those related in the first degree of consanguinity. The court, it already considered the competing policy considerations, and it had to, the result is the drawing of this line. And yes, there will be plaintiffs on the other side of the line, but
So you don't, Chief, if I may.
Judge
So
Fineman?
your position is that nothing's changed in the last 30 years about society's view of non-traditional families and others, and that it's still okay to limit recovery to spouses and first-degree blood relatives.
yeah,
That's your position?
yes, I mean, it's,
And yet, we've done so many things in other areas of the law. So how does that promote the average person's understanding of who is a close family member or who should be considered part of the immediate family, whichever term you want to use?
it's this ruling is not, shouldn't be viewed as a statement of the importance of a particular family member. It's where it's the competing policy limits. The plaintiffs have been permitted this bystander recovery, and at the same time, the defendants there's a control on the degree of liability. I mean, what was ignored by the appellate division dissent is that every time the court expands liability, it expands the cost, and that cost is ultimately felt by the public.
Judge, if I may ask.
Judge Rivera?
Yes, thank you. So, yes, I get your point, counsel, that the defendant always seeks to pass it off to someone else. I understand that point. But here what I wanted to ask you is, under your understanding of our jurisprudence, are domestic partners covered? Could a domestic partner bring such a claim?
I would, under the current state, if they adopted the child, or I guess you mean domestic partners of each other.
Let's just do a domestic partner. Correct. Not talking about children now.
If they would be considered married under the law, then they would be.
No, they don't marry, but they're domestic
married.
partners. That's the point.
Then no, under the current state of the law.
Are stepchildren covered?
No.
No. Okay. So even though the kinds of family connections I've just identified are, first of all, as close as you get to the other legally recognized or biological connection, and in other ways the law has recognized them, you would say, no, this is just married couple during the marriage. I assume after divorce they don't count, right? It has to be the married spouses, siblings, and their children.
Right.
Does it include the spouse of the sibling?
Who is the injured
Or
party?
why does that matter?
Well, because if it's the sibling and the spouse, they're married. So they would be covered.
No, I'm sorry. The spouse, if it's the parent of the sibling.
Oh, so the father-in-law, in other words. Or
Yeah,
the
the in-laws. That's a good way. Thank you.
No, because it's not within if they're not married or within the first degree. And I understand that it's arbitrary, but that's a product of the analysis and the defining the
Yes,
scope.
and that again is, I understand your point. Your focus and the council spoke before you, is we've got to limit liability, draw the arbitrary line, even if there's arbitrary and there's arbitrary, right? There's arbitrary where you just say, look, that's where the line has got to be drawn. And then there's arbitrary that is rather jagged because what you're doing is eliminating people that in any logical sense are included. In my example, spouses could be your defining line, but it makes no sense to keep out domestic partners if they are treated like spouses in every other way, right? That
Right.
To me is the difference between the real raw arbitrariness of something and an arbitrariness that has a function, that is to limit liability for a particular purpose. But I think.
Right. I would just also say that in most of these cases, the plaintiff has other items of damages that they can recover. So that in most cases, they're not precluded from full recovery. And I think that the reasoning in Trombetta in limiting liability and limiting the cost to ultimately the public is even more relevant today when multi-million-dollar verdicts are now commonplace.
Well,
Thank you,
if I
counsel.
may- I'm sorry.
Yeah, Your Honor.
Rabinowitz?
Thank you, Your Honor. Thank you, Judge DeFiore. I want to start with what Judge Stein said, and that was that grandparents enjoy a very special relationship because that factors into exactly what Judge Fahey said when he asked the question, what is the public policy reason to exclude grandparents? And there was no answer to that. And there is no answer to that. As far as the flood of litigation, there cannot be a flood of litigation. And the reason is this is not a separate action in and of itself. It's merely another cause of action to be added. It will add no cost at all.
Let me ask a question. I appreciate what you're saying about grandparents, but I'm hard pressed to believe that in 1993, when Trombetta was decided, people didn't appreciate, and as a society, we didn't appreciate the role of grandparents.
So what I'm saying is this: grandparents should obviously be part of the immediate family. I don't even have to go to the restatement third. But what I am saying also is, to answer the questions that you were asking, Judge Rivera, about, for example, the partners, yes, they should be able to recover. They certainly should be able to recover if, in fact, they suffered zone of danger damages that were negligently inflicted. That negligent infliction of emotional distress has to be redressed. And tort law actually does allow for redress in our courts. That's why Broadnax, the Court of Appeals, actually carved out a common law exception. They actually said, we need to solve this, and we have to solve it, and they did. And this court actually did solve that problem. So what I'm saying here is, yes, grandparents do play a terribly important role in the lives of their grandchildren. And yes, as time has moved by, things have changed tremendously. If you take a look at, for example, gay marriages are now recognized, and they should be. But to say what happened 40 years ago, to try and voice that type of reasoning in today's world does not work. And that's why we're saying here, certainly, there should be a remedy for a grandmother who witnesses her granddaughter crushed in front of her eyes, and they should be able to recover.
Thank you,
Your Honor.
counsel.